Welcome back to online classes. Yes, students, today I am going to discuss with Indian Penal Code. I am James here. This online classes continues with earlier online classes. Okay, because last class we discussed with the section 376 subclass 2. Okay. So this online classes, the continuous class, and subtitle consent and will. Consent and will. Here, in order to bring home the charge of rape against a man, it is necessary to establish that the sexual intercourse complained of was either against the will or without her consent. Where the consent is obtained under the circumstances enumerated under class 1st to 6th of section 376 of subclass 1 or 2, okay, the same would also amount to rape. In leading case, Dilip Singh versus State of Bihar, the Supreme Court observed that though will and consent often interlace and an act done against the will of the person can be said to be an act done without consent. Okay, the Indian Penal Code cognizes these two expressions under separate heads in order to be comprehensive as possible. The sixth class of section 375 of IPC, earlier section 375 of IPC only, because the ingredients only 375 of IPC explain about, not 376 subclass 2. Okay, that is amending act. Okay, that is punishment area. Here this is ingredient of the rape. So here the sixth class of section 375 of IPC is not attracted since the prosecutrix has been found to be above 16 years, although below 18 years. In the fact of the case, what is crucial to be considered is whether first class or second class of section 375 of IPC is attracted. The expression against her will and without her consent may overlap sometimes, but surely the two expressions in first and second class have different connotations and dimension. The expression against her will would ordinarily mean that the intercourse was done by a man with a woman despite her resistance and opposition. On the other hand, the expressing without her consent would comprehend an act of reason accompanied by deliberation. Okay, student, and also age factor in consent. The next theme is age factor in consent. Here, in the case, the prosecutrix was below 16 years, that means not below, that means now 18 years of age at the relevant time. The issue of consent becomes totally irrelevant where the school certificate showed the age of the prosecutrix to be 13 years and 5 months on the date of the incident, but the medical opinion about her age was between 16 and 17 years. It was held that the school certificate would prevail since the medical opinion is based on estimate, and therefore the possibility of error could not be ruled out. The transfer certificate has been issued by a government school and has been duly signed by the headmaster. Therefore, it would be admissible in evidence under section 35 of the Indian Evidence Act. However, the admissibility of such a document would be of not much evidentiary value to prove the age of the girl in the absence of material on the basis of which the age was recorded. The date of birth mentioned in the transfer certificate would have no evidentiary value unless the person who made the entry or who gave the date of birth is examined. A register maintained in a school admissible, okay, in evidence to prove date of birth of the person concerned in terms of under section 35 of the Evidence Act. Such date of birth are recorded in the school register by the authorities in discharge of their public duty. It may be true that an entry in the school register is not conclusive, but it has evidentiary value. Such evidentiary value of school register is corroborated by oral evidence. In this case, as the same was recorded on the basis of the statement of mother of the prosecutrix. Now it's understand? Corroborating, confirmation. Without confirmation, what happened? Is going down. Okay. So the doctor examining the victim opinion that she was subjected to sexual intercourse and gave reasons for the conclusion. The age of the victim was determined be 13 years by the doctor examining her X-ray reports. What is the X-ray reports based on this bone and skeletal? Okay, these are all presumption by the doctors, medical reports. And plea of consent was considered be not acceptable. Conviction of the accused was held to be proper. The prosecutrix was stated to be in love with the accused and consenting party. The court said that a careful determination of her age became imperative. The clinical examination showed that she held well-developed secondary sex characters. Admission form of school also not produced. The school leaving certificate which was produced was obtained a few days after the incident. Father indicated her age approximately only. So the Supreme Court said that conviction on the basis of such evidence was improper. Okay. Okay, students, and another main point of this section, custodial rape. This is very important now modern days also. Many custody of women, there is no protection from the males. Okay, not only custody of the guardian, custody of the parents also. Many cases we have seen in this newspaper. What happened? The sluggish peoples, his mind also dirty one, like septic tank. This is my word. Okay, the irritating mind peoples, they don't know how to behave with daughters, how to behave with peoples, small child, 2 months, 3 months also. So those who are custody in those persons, what happened? Need protection. Who will give protection? Law. So now our Indian law also protected by the system, but this culprit people, like this dirty peoples are doing regularly, habitually are doing like this. So we must cut short that particular persons. How? Those who are studying law students and those who are practicing as a lawyer, those who are sitting judges, those who are lawmakers should be strictly corrected this type of offenses. Okay, let's go. We'll start this portion as per this section. The custodial rape, the prosecutrix and her husband were taken into custody by the police on a false plea. that she had been abducted. At the police station, they were kept in a separate room and she was raped by the accused head constable. Head constable is the police graded person, okay, is coming as to seniority. Police, then his seniority level is head constable, okay. So his conviction under section 375. Okay, student, another point of view, rape by headmaster. I think this also custodial rape. Here, now the teaching profession is a very important one. Okay. At headmaster, what will happen? I will give you a small portion of this case, outline of this case, because if I am giving elaborately each and every cases, we don't have any time and all. So that's the main reason I'm giving outline of these cases. Okay. After that you can develop in your own knowledge and refer with as per the reference book also. Okay. Dear students, here as per the sections explained based on this reference case, rape by headmaster, a foolish man. Okay, foolish man or dirty man, like septic tank, or another name like in Tamil word Kuvamaru. Okay, like Kuvamaru. This Kuvamaru Kuvam river peoples, the dirty inner minds. These peoples will remove from the justice. Okay, students, rape by headmaster. The girl was sent by the mother to the house of the accused headmaster for cooking purpose. The accused followed her and committed sexual assault. Their absence from the school was confirmed by student witness. The statements of the girl were found to be true. She narrated the incident to her mother immediately on arrival at home. Okay, presence of semen and human sperms on the clothes of the girl corroborated her version. Even if it was not proved that the semen belonged to the headmaster, the Supreme Court did not interfere in the order, setting aside his acquittal. In the case of a rape by a teacher of his student, it was held that question of consent was really a matter of defense by the accused. Okay, it was for him to place material before the court to show that there was consent. The High Court erred in putting the burden on the victim to show that there was no consent. Okay, that's all, students. That also custody. Okay, we'll go to class 4. What is that class 4? Section 375, subclass 4. What is that? Husband and wife. Class 4 deals with rapist who knows that he is not his victim's husband and also knows that her consent is given because she believes that he is another man to whom she is or believes herself to be lawfully married. Apart from any such error on her part, an English court has held that there is no longer a rule of law that a wife is deemed to have consented irrevocably to sexual intercourse with her husband. Okay, and that therefore a husband can be convicted of the rape or attempted rape of his own wife where she has withdrawn her consent to sexual intercourse. In this case, because of matrimonial difficulties, the wife left the matrimonial home and returned to live with her parents, informing the husband of her intention to petition for divorce. While the wife was so staying at her parents' house, the husband forced his way in and attempted to have sexual intercourse with her, in the course of which he assaulted her. Note down, assaulted her. And also his conviction for attempted rape and assault occasioning actual bodily harm was upheld. Okay students, 5th class, section 375 subclass 5, explain about pregnant woman. Stringent punishment has been provided for commission of rape on a woman known to the culprit to be pregnant. It is therefore necessary knowledge of the accused should be established by evidence. A mere possibility of knowledge would not be sufficient. The class would not be attracted where there is no evidence to show guilty knowledge. The minimum sentence prescribed under section 376 subclass 1 would be applicable. Okay, and 6th class of 375 IPC, under 16 years of age. The age limit in this class was raised to 16 years by an amendment of the Act in 1949, where the birth register showed the age of 14 years at the relevant time, but the medical opinion put it to be between 14 and 16 years. What happened here? It was held that the birth register should be performed. The books on medical jurisprudence carry in that medical opinion cannot be absolutely uncertain, and that 2 years plus or minus error was possible as per this age. Okay, here where a girl of 7 years of the age was victim of rape by her own uncle, and apart from her testimony being corroborated by evidence of relatives, the medical evidence confirmed the episode, conviction fallout. Okay, the submission of her body by the prosecutrix under fear or terror cannot be construed as a consented sexual act, and Supreme Court in this case that the fact of consent is to be ascertained only on careful study of all the relevant circumstances. The evidence on record showed that the prosecutrix was below 16 years of age. She resisted the sexual onslaught. Thus consent was nullified both by the statutory provision and the fact of resistance. Medical evidence corroborated her statements. The acquittal of the accused was set aside. And also, in case of rape and murder, the dead body of victim was found on a cot inside the house of the accused. This is another example. The latter did not explain the circumstance. A presumption arose against him. Acquittal on the ground of absence of resistance was held to be wrongful. There was injury on the right side of posterior labia minora. This could not be ignored as a mark of resistance. The doctor's finding was of a fresh tear on the vaginal wall. The victim was throttled immediately after the act of rape. This fact strongly suggested vehement resistance. The fact that victim might have had sexual intercourse prior to the rape, as shown by the absence of hymen, was of no consequence. So here they are explaining the duty of the court in connection with the charge of rape. The court said that the court must show great sensitivity in such type of trials. They should examine broader probabilities and not get served by minor contractions or insignificant discrepancies in statements of witnesses. This is all the more important because of the later there is rise in crime against women in general and in rape in particular. Okay students, and also gang rape, that is class G. Class G means section 375 subclass G. Explain about, that is 7th class, gang rape. What are the ingredients we need? Okay students, that is section G classes will discuss with another class, because this is also lengthiest portion. We just wanted to concentrate, then only you all understand about this class. Best we'll discuss with next video class. Okay, bye students, take care, all the best, thank you.